us today. You can also review the recordings after this session ends. Welcome, everyone. We still have about a minute before our session begin. I will let everybody rolling in, give everybody some time. At the meantime, I will speak about today's sessions. There is a mistypo on this. I just realized that, so let me clear this up so there is no confusion. Okay, so today's session, we're hosting it with immigration attorney Marta Meng. Marta is a long-term friend with us. We've been doing webinars together, collaborating together for a while now, probably 2, 3 years for now. And then today's subjects will be focusing on immigration changes and what possibly could be changing in the future after Trump's new administrations. So we're going to cover some of the executive orders. Some of them you might already heard of. Um, what are the potential impacts on foreign workers and students? So we're going to focus specifically more on the students and workers side. So maybe in another session, we'll talk more on green card and immigrations. But today we'll want to focus on more on things like H-1B, F-1, and then if you take a look at the session spotlight, we're also going to cover CPT, OPT if possible. And then in the second half of today's session, we're going to talk about we're going to do a live Q&A with immigration attorney to directly answer your questions totally free of charge. So if you do come in with any kinds of questions related to today's topic, feel free to drop a name into the Q&A session. Our teammate here is going to collect all of them and hopefully answer them for you. Before we go ahead and begin today's sessions, I want to ask everybody if you do have questions, concerns about CPT, if you're currently going through day one CPT applications, feel free to contact us. Here's our contact information down below. You can scan either QR code to connect with us for a free consultation. So a little bit of information about who we are. We are GoElite. We are here in Los Angeles, Pasadena. We are in the business for about 6 years for now. And our primary service would be day one CPT University assistant applications, consultations, and stuff like that. And then we also help out on the F1 reinstatement or emergency transfer cases, as well as some of the change of status applications. So our mission is always to make students' dream come true, and we're certified by AARC as one of the most respectful organizations in the education industries. So feel free to check us out. And I'm happy to announce two of our recent activities that we would be happy if you would like to attend. There's plenty of rewards here. For example, the first one, the Day One CPT communities. If you join the community, there's plenty of rewards, if you can see in the right, to earn points that you can exchange into gift cards. And then our second activity here, which is, just about to begin, is our free H-1B blessing event. So this year we hosted in India and China. So if you're interested in to boost up your luck just a little bit, we can bring your wishes to Visa temples or the Chinese temples free of charge. So you just have to click the link below. We will share the link in the resource tab in today's Zoom session, and you can click the link. It's free of charge. We'll bring your wishes to the temple, and we will mail you one of the cards as you received. And hope everybody do have a good luck. I know H-1B session is coming really, really soon, and hope everybody do have a good luck on that. We're also on Google reviews. Feel free to check us out on Google and to see what other students have said about us. And we're on all the social media platforms. Feel free to follow us to check out our amazing content. And without further ado, I will stop sharing. And then Attorney Marta Meng, you can start sharing.
Thank you, Ryan. Thank you very much for having me today, and thank you everyone for attending today's webinar. So I'm here today to share with you some of the update in the immigration news. So we're gonna mostly be sharing about what to expect and what does some of the recent executive orders or policy changes mean? Like, what's the implication, especially for current international students? Okay, so first of all, some disclaimer. So today's webinar is for educational purpose only. Any information shared here is not supposed to be legal advice for your specific case. Even I answer any of your questions in the Q&A session, please remember that's general information. It's not case-specific advice. So if you would like to have case-specific legal opinion on your case, please, make sure you retain us or any attorney with agreement, okay, like a written agreement for that. And also anything here is supposed to be for educational purpose only. And we have authorized GoElite to probably upload the information later on to the GoElite YouTube channel. But please do not share any clips, any screenshots from today's webinar to your social media accounts. We don't want anything to be taken out of the context. All right, so some disclaimer up front. A little bit more about myself. I am an immigration attorney. Our office is based in Los Angeles, California. I have been practicing immigration law for more than a decade now. So I've been through the Trump 1.0, those 4 years we've been through that. So we also have all these experience seeing these immigration policy changes from administration to administration. So we are gonna share from some of our past experience today. Okay, and I focus mostly on employment-based immigration cases. That means mostly work visas, all kinds of EB cases, EB petitions. We also deal with student status a lot because a lot of those work petition beneficiaries are students. So if you have any questions related to work visas, employment-based petitions, or student status, feel free to leave your questions in the Q&A. I'm gonna get to that at the end of today's session. All right, let's get started. Okay, so first we're gonna be talking about the recent executive orders. As most of you probably knew from the news that President Trump signed tons of executive orders day one in office. Some of them are related to immigration policy, potential policy changes. I know one of them got a lot of media attention that is about the birthright citizenship, which has already been blocked by one federal judge. But another one actually probably would have more impact to students and work visa holders. So we're gonna analyze some of the language there, but we don't have the details yet because the executive order signed by the president doesn't have all those details, but it does direct all the department head to work on those details. So we probably will see the actual policy with more details in the next couple months. But we can get some ideas of what to expect, right? And we're going to be talking about the H-1B modernization rule. So that rule took effect this month, January the 17th, I believe. So it's already effective now. That was a rule finalized and released by President Biden before he left office. So there's a lot about the changes to the immigration, like the H-1B, like immigration policies. So we are going to be talking about that a little bit. One thing that got a lot of attention was the beneficiary owners, right? So right now, if you own a company and even you are the majority owner that owns like more than 50% shares in the company, you can petition H-1B for yourself as well. So that is a big change. In the past, if someone has more than 50% shares in the company, it's very hard for them to be petitioned through that company. It's not completely impossible if they have some sort of, structure to, like to have some sort of governance within the board. It's still possible, but in most cases, if someone has more than 50% shares in the company, they probably would have a hard time to get H-1B through that company. But now that is possible. Okay. We're going to also be covering the CPT, OPT compliance requirements a little bit, and then we're going to open for Q&A. So the first one is the executive order. So this is the name of that executive order. It's called like Protecting the United States from Foreign Terrorists and Other National Security and Public Safety Threats. Okay, so within that executive order, some of the language is a little concerning. Okay, as I am copy pasting here, it mentions some more rigorous and strict vetting process. So the language here says vet and screen to the maximum degree possible, particularly, those aliens coming from regions and nations with identified security risks. What are the nations with identified security risks? We don't know yet. Okay, so here it says within 60 days from of the date of this order, the Secretary of State, along with some other, statement like department head would announce more, right? So they're gonna issue some reports, so we would see more detailed policy. But right now, at least we know, like for countries or regions that are are considered to have, this identified security risks, you know, they might have a, more strict policy when the overseas like visa officers issue those visas, right? And then here, the last one on this page saying identifying countries throughout the world for which vetting and screening information is so deficient as to warrant a partial or full suspension on the admission of nations from those countries. That is even more scary. We're talking about travel ban, right? So it can be a partial travel ban, it can be a full travel ban for people from certain countries. So those countries, obviously, they probably are not the kind of countries that are traditionally considered like allies of the US. Probably they don't share that much information with the US as a country, but which countries would be on that list, we don't know yet. But this we're talking about a potential travel ban. So I saw maybe in the Q&A, and we also have got sometimes questions from clients asking, "Oh, is that true that we cannot travel right now?" Well, I would say it is prudent to reconsider your travel plan if it's not for something like really like an emergency, right? Because we don't know yet what kind of travel ban would be issued and when that would be issued. It can be anytime. Most likely, we're going to see that anytime in the next month or maybe the month after next. So this is something that we should closely monitor. Okay, so that is why you might have seen in the news like, or you might have got some notice from schools advising you to not to travel if possible, avoid international trips as much as you can. And this is why, because there's a lot of uncertainty about visa issuance like overseas, and also maybe some of the citizens of certain nations would have a hard time re-entering the US. Okay. Here, so there's some additional steps taken. Okay, it's a lot of words here, but the main idea is we're talking about some kind of ideological screening, like So here, we're talking about like say section like the clause D, right? Recommend any actions necessary to protect the American people from the actions of foreign nationals who have undermined or seek to undermine the fundamental constitutional rights of the American people, including but not limited to our citizens, to freedom of speech and the freedom, the free exercise of religion protected by the First Amendment. I mean, my personal opinion is, foreign nationals won't have the ability to jeopardize any of the U.S. citizens, constitutional right? That most of the like the constitutional rights, including the First Amendment right, are between the government and the citizens. But this is what's in this executive order. So here it calls to, for more strict vetting to those who preach or call for the sectarian violence, the overthrow or replacement of the cultural on which our constitutional republic stands. So, what does that mean? It can be more screening for those who apply for visas, right? You might have already heard of like visa officers search people's social media online, right? So that can maybe apply to more people. That's a possibility. Maybe there can be these questions regarding social media, not only at the visa application stage, but also at some sort of other application, right? Maybe they would ask for those identifiers of social media in some other cases. That's also possible. So there's a lot of uncertainties here regarding who will be subject to these additional screening and how strict that would be. So that is why we would advise most students or those who are on work visas to avoid international travel until we have more information, right? Those policies, the actual policies with more details are released. Okay. All right, then the next one, H-1B modernization rule. So this one was released by the Biden administration. It's really good because this one was already finalized and it became effective before President Trump took office. So we know like President Trump has already, asked to halt all these current rules, like rulemaking process within the administration, right? They're going to review one by one to decide which ones to proceed and which ones they might just cancel. But this one, since it already became effective January the 17th, so it is applicable to all the H-1B cases, including this year's cap subject H-1B cases. Right. The first one, beneficiary owners, as mentioned, even you are the majority shareholder in the company, you can petition yourself, not only for the cap subject H-1Bs, but also for, like, say, the change of employer cases, right? If someone is currently in H-1B status, they want to start their own business, which is no longer subject to the lottery, they can do that as well, right? The only limit is they cannot request full 36 months validity period in the first two petitions. So in the first two petitions, this petition, this, beneficiary owner company can only request 18 months. Not too bad, right? You can still request extension, but it would have a shortened validity period in the first two petitions. This is kind of like similar to L1, right? Like in L1 cases, if that's a new office, it will get shortened validity period. It gets like 1 year as opposed to the 3 years in regular L1. So that's understandable. That is a way for USCIS to just check a little bit more closely for those new offices, making sure those are bona fide job offers, right? Those are real business. Okay. The other is about cap gap. Okay. So for those whose F1 or OPT expires, sometime before October the 1st, if the company files the H-1B petition for you. So we're talking about the actual filing after being selected, right? Only registration doesn't count. It has to be the actual filing. So if the H-1B filing is made before your current OPT F1 status expire, then the beneficiary status is going to get automatic extension. Currently, it's only getting extension to September the 30th, which a lot of times is not enough because, USCIS may take longer to adjudicate, which, makes it really difficult for the beneficiary and the employer as well, because either the person has to stop working or they have to pay for the extra fee, right? The premium processing fee to get the decision sooner. According to this new rule, the cap back gap would be extended until April the 1st next year. So that's a great news. So as long as the H-1B petition is filed timely, the beneficiary doesn't have to worry that much about not getting a timely decision so that, the person may lose the work authorization, right? So that's also good news. Another big change is to the definition of nonprofit research organization, right? So those organizations are cap exempt employers. So they don't have to go through the lottery, okay? But who's considered nonprofit research organization? In the past, it was very hard to qualify as a nonprofit research organization because the organization has to prove that research is something the organization primarily engaged in. However, right now, it doesn't have to be the primary mission. It only has to be a fundamental activity of the organization. Well, they sound quite similar, but they actually are interpreted very differently by USCIS because an organization may only have one primary mission or very limited primary mission, but you may have more like fundamental activities, right? So that may uh, qualify more nonprofit organizations as H-1B cap exempt employers. Okay, that's also good news. But just remember, you don't necessarily have to be a nonprofit research organization to be cap exempt. If that is a nonprofit organization that has affiliation with higher education institution, that may qualify as well. We actually have seen a lot of nonprofit who are not aware of that their own cap exempt status because they were under the impression like you have to be universities or you have to be like say this one nonprofit research organization in order to qualify. But as long as you can prove affiliation with those universities, that qualify as well. So affiliation, there's a lot of room to argue for affiliation. So for a lot of people, they consider affiliation to be something like you have to be like, say, let's say we're in LA, right? So USC, right? You have to be like a center, like maybe some sort of center on the campus of USC to be considered affiliated. No, it doesn't have to be like that. For a lot of the nonprofit, especially for those who do like community service work, they may have some sort of agreement with universities to receive interns, right? So they give like those credits to those interns from that universities. So that kind of collaboration may be considered affiliation as well. So just a reminder, if you happen to be working at a nonprofit, look into this cap exempt qualification definition, like maybe the organization is qualified. All right. Okay, a lot of people are asking what is the future of H-1Bs? Because recently President Trump had an interview and he said a lot of things, great things about H-1B. He said he likes H-1B. He's gonna give out more H-1Bs. And he also were trying to educate, whoever was interviewing him, H-1B was not just for the engineers, it can be a lot of occupations. So one example he gave was for highly competent like waitress. So that actually made that like, cause quite some confusion among our clients. Some of them like are asking, is now H-1B extended to more occupations? No, no. So H-1B is a type of visa for specialty occupation. So, in order to qualify for this specialty occupation, this kind of occupation, this position has to prove that it requires someone with at least a bachelor's degree in certain major to perform the duties. So, for example, like say a waiter or waitress, typically that kind of position doesn't necessarily require a bachelor's degree in certain major. So those won't be qualified for H-1B visa. I don't know, maybe sometime in the future, maybe with a lot of automation, I don't know, like maybe that thing would change, but at least right now, from our understanding of what a waiter or waitress does, that won't qualify. But Trump is right. It's not limited to engineers only. So for a lot of other occupations, as long as that is kind of professional work, and it requires specialized, knowledge. It requires at least a bachelor's degree in certain majors to do the job. It's possible to apply for H-1B. So besides engineers, a lot of like analysts, a lot of designers, of course, accountant, lawyers, architects, those are also traditionally H-1B positions. Okay. Whether Trump would have, more favorable policy toward H-1B, we don't know yet. We hope it's not as bad as Trump 1.0. So the H-1B approval rate dropped more than 20% during the last 4 years of Trump administration. But this time, this term is a little different because, a lot of the Silicon Valley tech companies, including, someone like Elon Musk, right? They became some sort of a force to offset some of the policies from those anti-immigration policymakers such as Stephen Miller. So this is a force that was absent last time. But how much say do they have in the actual policy making for H-1B? We don't know yet. But this is something new during the Trump 2.0. So that's something different from the Trump 1.0. Okay. But does that mean like they're gonna raise the prevailing wage for H-1B visa this time, or they would find some way to make the H-1B make it more accessible to the tech companies more than those other companies, that would also be very hard. So I would expect at least some rulemaking process would have to be completed before that kind of change would take place. So we will monitor, all these rule making changes closely. But at least for the immediate cap H-1B, the registration, the lottery, the cap subject filing, we don't really expect too much change immediately. Okay, so the H-1B modernization rule would still be the rule governing the immediate H-1B lottery and the post-selection actual filing. Okay, and as to the H-1B selection rate, every year that is the question from client, what is the selection rate? Well, nobody knows because we don't know how many registrations would be this year. But I would expect it's about the same level as last year. So last year, it was when USCIS made this change to the H-1B lottery system. So last year was the first time USCIS was implementing this so-called beneficiary-centric lottery. So that means for each beneficiary, they're going to be counted only once, regardless of how many companies sponsoring them, right? Maybe like one beneficiary has like 10 companies sponsoring him or her, as long as that's the same person, that registration is going to be counted only once. Okay, so that's supposed to be a more fair system, right? But the demand is still very high. As we can tell from here, the total quota is still 85,000, but there were 470,000 registrations. USCIS selected almost 140,000, like less than 140,000 registrations through two rounds of selection. Some of you might be wondering why USCIS selects that many, because the quota is only 85,000, right? Because some of those selected registrations didn't end up with filing. So some of those selected cases, somehow the employer just decided not to proceed with the filing. That's why, they selected more registration than the actual quota allows. So I expect this to be the same case this year. That means the selection rate would be most likely still somewhere between 25% to at most 30%. So that's the selection rate from last year's data. And I expect to stay within the same range for this year. Okay. All right. Is that going to be more strict? Well, I mean, currently the H-1B approval rate is really high. It's almost like 98%. But that includes all cases, right? So this year, because a lot of new companies and like say those beneficiary owner cases are allowed to apply as well, I would expect, more RFEs can be issued on those cases. These are the common RFE reasons for in H-1B cases. The first one is about specialty occupation. The H-1B modernization rule actually changed the way specialty occupation is interpreted, but it's really up to the current administration how they actually implement it, right? But this is supposed to be more relaxed under the current modernization rule. The second one is about wage level. During the last 4 years of Trump administration, they made a big issue of the wage level, right? They were really hard on those level one wage occupations. But then over the time, that was resolved. But just want to give everyone heads up, especially for those startup company where the beneficiary is also an officer within the company, be that a CEO, CFO, that kind of role. You need to be very careful with the SOC code and the wage level because if you claim yourself to be an engineer, but at the same time you're the CEO of the company, it's very likely USCIS may back and question that, like, you might not be paying yourself the right wage, right? So that's something we need to kind of factor in when we explain, when we describe the job duties of the position. So I personally anticipate this to be a really complex issue, and this is something that can trigger more scrutiny from either USCIS or maybe even DOL about the wage level determination. Third one, employee qualification. That's not that big an issue for most people, but if you are taking a job that is not closely related to what you studied in school, that can potentially be a problem. And then sorry, there's a typo here. And then the next one is about employer-employee relationship. That would be more of an issue for those who work at those consulting firms, right? So if you are sent to a client site, so that's when that issue may be raised in some cases. Bona fide job offer. So that comes up more in cases involving startup, like new companies, or where, like say the beneficiary owns a big share, like, is a majority shareholder in the company. So a lot of people ask like, oh, what is the requirement of the company if I'm a shareholder in the company or I'm even the majority shareholder in the company? There's no rule about what's the size of the company or how much revenue the company has to make. It's just the same as all these other H-1B petitions that you have to prove that there is a bona fide job offer. You have to prove the company does have the need for such a position. So that is still the same rule applying to all petitions. Okay. The other one is about the valid status. This one started during the first Trump administration. It continued into the Biden administration, and I expect this still to be an issue that will be strictly scrutinized by the USCIS when adjudicating H-1B petitions. So you need to show that you have been maintaining lawful status in the US when you are requesting change of status or extension of status. So I know a lot of you might be wondering what needs to be done, especially given that Bloomberg recently had this coverage of CPT. If we go to that report itself, it also acknowledged that CPT on its own is legal. That we can find the legal authority of CPT, right? But it's how it's issued and then managed and used that would make a difference. So if some schools abuse the system, then those schools are more likely to be under strict scrutiny by the USCIS, right? Or if you as a student is kind of abusing the system, you don't go to school as you're supposed to, you can be in trouble. But if you can continue the attending the school as a full-time student, what do you do at the company, at the entity is related to what you study at the program. That's an integral part of your curriculum. You can still prove that you are in compliance of all these F1 rules, right? So that is something important, especially right now. Compliance is, I would say, compliance is something really critical to them, to all the students. If you're in OPT status, making sure you report any changes timely for a lot of those changes, right? Like say change of employer or change of address. Okay. Be sure you report those timely in your status record. Okay. And these are some other type of visas. Just a uh, quick reminder to everyone when you are planning your status, make sure you distinguish the green card from the work visas, right? So, whatever work visa you're planning to get right now, you also need to think about how you want to get the permanent residency if you plan to. So within the US, you have to you know, proactively like apply for the green card. It's not like if you have work visas for certain amount of time, you're going to automatically become a permanent resident. It doesn't work like that. You have to, apply for it. So how do you apply for it? That's something to think about. So usually that's either, it's one of those listed options, right? You have a family member that can be through like marriage, that can be through some other family members. Then you can have family-based petitions, or you have employment-based petitions, right? For employment-based petitions, that can be based upon a job offer from the employer or your own achievements, right? EB1A, NIW, or investment like EB5, right? So just because you file those petitions, it won't give you any rights to stay and work in the US. You have to wait until your priority date becomes current in the visa bulletin, right? That's when you can start filing for the I-45, and that's when you can be authorized to stay. So get familiar with how the green card process works. It's two-step. You file an immigration petition, and then you wait for the visa bulletin, right? Like you check the visa bulletin monthly, making sure you monitor that closely. So whenever your priority date is earlier than the listed date in the visa bulletin, you can file for the I-45. So what I'm showing here is a visa bulletin for February 2025. Okay, the wait time for like say China mainland board or Indian board in the EB2, EB3 is pretty significant. All right, so for the China mainland board EB2, it's currently April 22nd, 2020. So the wait time would be almost 5 years, right? For EB3, it's a little shorter slightly, but still we're looking at probably 5 or even 6 years wait time. For Indian board applicant, that is October the 15th, 2012. All right. For other countries, please note that if you are in the EB1 category, then that's good. That's current. But if you're in the EB2 or EB3, you also have to wait. Okay. So for the worldwide, there's also a visa backlog right now for EB2 and EB3. So you won't be able to immediately get authorization to stay when you start the green card process. You also have to wait. So you need to carefully plan your status, making sure there's no gap in your lawful status within the US. All right, so that's pretty much the end of today's session. So we're gonna open the floor for questions.
All right. Thank you so much, Attorney Meng, for your wonderful presentation. Let me just quickly switch up to my presentation slides. Can you see my screen now?
Yes.
All right. So we have collected everybody's questions. I'm gonna go by order. First question, I'm on day one CPT and my previous visa, the F1 visa, has expired. So some immigration attorney previously advised against renewing the visa because there is a possibility of getting rejected. So given this, what kind of document, if I do want to get that visa renewed, what kind of document should I absolutely bring when I do have to travel?
Yeah, as we mentioned, I also don't recommend traveling right now. I don't know which country you're from, but even like it is not a country with potential security risk. Um, F1 visa, especially you're currently on day one CPT, I think there's a lot of risk of renewing your visa overseas given that fact. So I agree. And just also letting everyone know, you don't have to go abroad to renew your visa just because it has expired, right? If you're in the US, as long as you have an active service, right? You have like a program you're attending and you're maintaining your status within the US, the visa, like that visa expiration doesn't affect your lawful status in the US at all. So visa only matters at the time of entry, right? When you are trying to enter the US from abroad, you have to have a valid visa at the time of entry. But after you successfully enter the US, it is the other things like the I-94, and for students, it is the I-20 and the service record that matters.
Yeah, absolutely. And for this person, sometimes we do have some reasons that we have to go back to our home country, and we totally understand that. We would still recommend, if you could, to wait just a little bit. As Attorney Ming mentioned, maybe wait for this month and February to kind of see what the current changes or the shifts could be. We currently do see people going back to China or India or even to Canada to get their visa, and we haven't seen any rejections for now. But I think ever since Trump do comes on there, we are anticipating changes. So definitely wait a little bit if you could. And then if you do have to go, I think some of our sessions, some of our webinars that we did with previous visa interviewers, cover some of the points that you absolutely should do if you're traveling on CPT. So I encourage you to check out our YouTube videos, our channels that have the previous live streams that you can learn just a little bit about how to get your visa approved a little bit easier. I hope that answers part of your questions. And let's move to question number two. Is it okay to file for EB2 while I'm on OPT, or is it recommended to go for H1B and file for the EB2 while I'm on H1B?
It's okay if you start the EB2 process when you're in OPT. So just because you file an immigration petition, it doesn't mean you're validating your status. So that won't be a problem. But be careful after you file the EB2 immigration petition or any kind of immigration petition, if you leave the country and you want to apply to renew your F1 visa, that can potentially be an issue. It doesn't mean necessarily your visa renewal would be denied for sure, but because when you're applying for the visa overseas, the visa officer has more discretion to decide whether you have immigration intent, right? So that can be denied on that ground. But if you're in the U.S. currently in OPT status, or even you need to file for OPT extension down the road, that is not something that would affect your current status. But yeah, if you have H-1B status, then you don't even need to worry about the impact on your visa application anymore because H-1B is dual intent visa. So even you are applying for a visa overseas, you are allowed to have immigrant intent. So that would be completely fine.
Absolutely. Next question will be just a little bit more complicated side, but I do feel like it's an important question to ask. So I'm a master student at CPT University, student day one CPT, and my EB1A 140 has been approved, and I'm pending adjustment status and F1 status now. Is it safe if I'm dropping out from the school right now, or how can the person go about it?
I see. First of all, congratulations on your EB1A approval. That's great. And it looks like you already have the I-485 pending. That's also great. However, I mean, I need to caution you that now that Trump is back and according to our executive order, right? That executive order, the vetting process it not only applies to those who are seeking admission into the US, it also applies to those who are already in the US. Okay, so that means, what does that mean? That means for those who are already in the US, like you, um, Trump administration can bring back the interview for the I-45, even for the employment-based cases. So that actually happened during the Trump 1.0. So during the last Trump administration, all the employment-based cases has to go through this interview as well, all of them. So but that was changed like during the Biden administration. So when it was President Biden took office, they changed that back. Most of the employment-based cases, if they file for I-45, they don't have to do the interview. Only 10% are selected to do the interview. But we all kind of expect that Trump is going to bring back the interview for all the I-45s, be that the family-based or the employment-based. So if the interview is scheduled for your case, I am very sure that officer is going to question your decision to drop that school. What's your reason of dropping that school? Do you have a legit reason? That's a very case by case question. We have seen in the past some clients they do have a like legit reason, right? Some of the applicants they like say they are pregnant, right? Like they are giving birth to kids. They cannot manage the school anymore due to those very personal reasons. But if you just drop a school with no reason, that could potentially be an issue if you are going through the interview process.
Right. This could be very complicated. And we do see successful cases, as you mentioned. And one thing I do want to note is that no matter what your reason is, your reason absolutely cannot be that I no longer need this CPT anymore. So that's the reason I'm dropping out. If you say this, this is not acting good for you. So be cautious of that. All right. Question number four. Do you know any information about Trump's statement in his campaign about giving green card to any international students who graduates from a college in the USA? We all remember that statement. I don't know what he said after, but will be very interesting to know about your opinion.
First of all, I hope everyone know like if such a big decision is made, it cannot be through the president on like say an executive order. That would have to be a bill passed by the Congress. Um, I don't think the current Congress is likely to pass something like this anytime soon. So something closest would be to maybe to exempt some people from the visa backlog, right? Like I remember when President Biden first took office, there was also some discussion about that as well, but it never really I don't think even like there was a vote on that bill at all. So this is not likely to happen. I don't know why, but people sometimes are taking those campaign promise, like some of the things, said a little casually during the campaign too seriously. Like, even like the H-1B, right? Oh, waiters can get H-1B. That's just not true. That's just some talk. This one, I definitely don't expect that to happen.
Yeah, absolutely. Next question. Do you think any new policy will be enforced before this year's H-1B lottery? I guess meaning that after the Biden changes, will Trump make other changes prior to April, prior to March?
Right. Probably not for this lottery, because the new H-1B modernization rule was like it went through the whole rulemaking process and it was released and it became effective right before President Trump took office. So if President Trump decides to make any changes to the H-1B regulation, he has to go through the whole rulemaking process as well. But that takes time. At least it will take several months to complete this rulemaking process. You have to propose the rule first. You have to go through the notice period, right? And then you have to finalize it. So that takes time. So it's already almost February. It's most likely won't affect this year's H-1B.
Absolutely. Next question, we kind of covered that in the presentations. So can I apply for H-1B on my own, or does the employer has to submit it on your behalf? And the short answer would be you do have to have an employer to file for H-1B petition, whether it could be your employer or even yourself being the the managing person of the company, but still you gotta have an employer to file for your H-1B. All right, let's move to the next one. I'm on E2S status. I'm not familiar with this status. Is it possible to adjust my status with day one CPT? Still in my current company. I guess changing to day one CPT was the same company, same position.
Right. So if you're in E2 status, yes, you can still change the status within the US. So for anyone who wants to become a student, you can either apply from overseas or you can change status in the US. So E2S is like a dependent visa status for the spouse of E2 visa. I don't know why you want to change to a student status. Is that because maybe your spouse is no longer holds the E2, so you cannot be like a dependent of the E2? But yeah, you can totally do that. And if you change status in the US, like right now, like change of status for F1 can also request premium processing, so you can get the decision sooner.
Absolutely. All right. Next questions. I think somebody really throwing some good news. I think Attorney Main also covered this piece of good news is that once H-1B visa lottery has been reformed, now is one person per registration, and it actually cuts the registration by 38%, the multiple registration. So that is the good stats. And then I think we did share a little bit on, the our concerns, Attorney May's concerns is that even though the rule has become more fair, there is just too much people wanting to get H-1B, so the competition level is still very high. So do keep mind of that. And then it's not likely that the H-1B lottery percentages, the chance to get H-1B is going to shift dramatically over the years because of the high pool of the big pools that we have, people wanting to get H-1B at the current moment. So moving on, I own a sole proprietorship. Can I also self-sponsor myself under these modern rules? I guess the simple answer could be yes, based on what we talked about. Uh, but we do need a little bit more information, I guess, from your side, whether or not your company or yourself uh,
Yeah, so if that's a sole
qualifies.
prop, yeah, if that's a sole proprietorship, I don't think so. That
Okay.
has to be a legal entity. If you mean that
Um,
is a company 100% owned by yourself, that is fine. So yeah, you still need a legal entity for that.
absolutely. And excuse me for what I've said. If in this case, we would absolutely recommend you to scan the QR code or email Attorney Meng to, submit more informations or let us know more about what your company is about or so that we can give you a more informed answer in terms of whether or not this is possible. All right, moving on. If I'm working for a nonprofit, does that mean that there's no cap on my CPT? I think there is a misunderstanding on this part. If you're asking about CPT or H-1B, I think we covered about these H-1B parts. But there is definitely fundamental differences between those statuses. And then if it is CPT, I don't think there's any caps for your CPT to answer your question. All right, let's
Right.
move on. A lot of people are curious about whether or not certain positions are are qualified for H-1B sponsorships. I think people ask about registered nurses. Other people ask about registered attorneys as well. Just wanted to have your opinion on this. If these people who actually go for H-1B this year.
Right. So for nurses, I have unfortunately like not all the nurses qualify for H-1B. So only certain nurses qualify for H-1B, and that is called the Certified Advanced Practice Registered Nurse. So that we need to look at, whether you qualify under this group and where you work at. So the answer is maybe, but not all registered nurses qualify.
Yeah. In terms of nurses, what kind of other work visa options they might have?
I would say, depending on what's your country of birth, you may consider having the employer start the employer petition for you, like the green card route
Mm.
for you. Because, registered nurses do have some more favorable rules when it goes to the employer sponsorship. So that is one route. But yeah, but for H1B, no, like registered nurses, not all of them can get the H1B.
Absolutely. Next question is a little bit of complicated and personal, but I think in general, this person wanted to know that um, if the person shift from an L1B status to an H1B status, how long can he stay on H1B? Because he previously already had the L1 for 2 years. Does he get another 3 years of H1B? or would that just be a limited timeline of H-1B?
Well, that's a great question. All the time spent in L1 status would also be counted toward the H1B 6 years. Okay, so if you spend 2 years in L1B status for already, then your 6 year won't be like a full 6 year. However, the 6 year of H1B can be extended. So if you already, let's say, have an I-140 approved for you, then you can extend H1B beyond the 6 year limit. Then it doesn't really matter whether you spend that 2 years in L1B status in the past. So most importantly, whether you have the green card process already started for you or not, whether you have the I-140, and if so, you won't have to worry about this previous L1B status.
Absolutely. And for timing's sake, I know we're coming to an end. Let's answer two more questions real quick. And then for everybody, if we missed your questions, we couldn't answer it this time, don't worry. We would do attorney sessions every month or even every couple weeks. And then we will soon invite attorney Marta Meng with us again. So hopefully we can address your questions later on. Or if you do wanted to know about some certain issues, answer specifically, especially into CPT, you can scan the QR code. Or if you want to talk to Marta, we can forward her contact information to you so you guys could have your private conversations regarding your issues. But let's just delve right into our last two questions. The first one is, um, this person wanted to know in general more about having multiple employers. So can you have more than one company sponsoring your H-1B or OPT or CPT, or how does that work?
Yes, yes, you can. But just remember, for multiple companies sponsoring you for H1B at the registration stage, it doesn't increase your chance of being selected under the current system. Okay, so you are still gonna be counted only once. And if you're selected, then both companies can proceed to file the H1B petition for you. Let's say if both companies do want to hire you under the H-1B visa, then you can be working for both. At least from the immigration law perspective, that is fine. As long as both company would pay you as a W-2 worker and they pay you at a rate above the prevailing wage level. So that's the requirement for H-1B. With OPT, yes, you can have and a CPT as well. You can have multiple, but as long as all these work are for OPT and CPT, they have to be related to your major, right? And for CPT, it has to be a part of like an integral part of your curriculum. So as long as those requirements are met, that is possible too.
Mhm. Um, the last question, actually, a lot of people are curious about this question. So, what is a safe starting wage level to avoid being concerned about whether or not I'm going to meet the H-1B wage level?
There's no fixed wage level for H1B. The wage level for the H1B position would really depend on several factors. One is the occupation, right? You don't expect like an engineer to be paid at the same level as like say a social worker, right? So that's different. What's your occupation? The second is your location. So even someone's working as a software engineer, uh, like working in like in Texas, it would be very different from working in Silicon Valley. So the location, even for same occupation, would make a difference too. And then third one is the company's job requirement. So even that is same occupation in the same area, but if the employer has very different requirements, that means like maybe the educational requirements or the work experience requirements or the skill requirement, that would also make a difference to the levels of wages. So it will depends on all these factors. So I cannot give you like, a fixed, like a magic number. As long as you're above that, then that's fine. It doesn't work like that.
Yeah, absolutely. One thing I will add real quick is that I throw in one link in the chat. So for everybody who is interested, who's going to be participating in the H-1B lottery, you can actually chat your locations or your job positions to get a general picture of what that look like in your specific field and location. So you actually can do your little research. We couldn't provide you with the exact answers, but you can do the research in the website link that I forwarded, and I hope it could be helpful. All right. Thanks, everyone. I think this comes to an end to today's session. We had a blast, answered a bunch of questions. Hope they will be helpful to you. And I do want to especially shout out to Attorney Marta Meng for joining us once again to give us a wonderful presentation as well as answering these questions wonderfully. So thank you everyone for joining us, and thank you Marta for joining us as well, and hopefully we'll see you really soon.
Thank you for having me. Thank you, everyone.
All right, everyone has a wonderful rest of your evening, and we'll see you really soon. Bye bye, everyone.